And introduction of the first proviso was directed to prevent unholy practice of pure trade, commerce and business entities from masking the activities and portraying them in the garb of an activity with the object of general public utility. It's not designed to hit at those institutions which had advancement of the objects of general public utility at their heart and were charity institutions. The attempt was to remove the masks from the entities which are purely trade, commerce and business and to expose their true identities. And the finance minister's assurance that object is not to hurt genuine charitable organizations, that was referred to. And therefore they said that in order to save the constitutional validity, it will have to be read down and interpreted in the context of 1020cc4. This was in the context of 1020cc4 because 1020cc4 also refers to a charitable organization. So, because the context requires that. Now they said section 215 is only a definition clause. Section 2 begins with the words, in this act, unless the context otherwise requires. And therefore they said that here the context otherwise requires. The expression charitable purpose is to be seen in the context of 1020cc4. When the expression charitable purpose as defined in 215 is read in the context of 1020cc4, we have to give up the strict and literal interpretation sought to be given to the expression charitable purpose. If an institution established for charitable purpose did not receive an income at all, then what would be the need for taking any benefit under 1020cc4? So they say that if they are not charging any consideration, then where is the question of exemption for any income? So firstly you have to have an income. So that was, if a meaning is given to the expression charitable purpose so as to suggest that in case an institution having an objective of advancement of general public utility derives an income, it would be falling within the exception carved out in the first proviso 215. Then there would be no institution whatsoever which would qualify for the exemption under 1020cc4 and the provision would be rendered redundant. This is so because if the institution had no income, recourse to 1020cc4 is not necessary at all. So if such an institution had an income, it would not, on the interpretation sought to be given by the revenue, be qualified by being considered as an institution established for charitable purpose. So if you are earning an income, you are not charitable. If you don't earn an income, you don't need an exemption. Then where is the question? So that was what. So either way, 1020cc4 is not available. Either because it is not necessary or because it is blocked. Therefore, intention behind introducing the proviso 215 would certainly not have been to render provisions of section 1020cc4 redundant. So they say that therefore you have to give it some meaning. The correct interpretation of the proviso would be that it carves out an exception for charitable purpose of advancement of years of general public, and that exception is limited to activities in nature of trade, commerce, business, or activity of rendering service in relation to trade, commerce, business, for a cess of any other consideration. In both activities in nature of trade, commerce, business, or activity of rendering service in nature of relation to trade, commerce, or business, the dominant and prime objective has to be seen. Again, it comes to that. If the dominant and prime objective which of the institution is profit making, whether its activities are directly in the nature of trade, commerce, business, or indirectly in the rendering of service in relation to trade, commerce, business, then it would not be entitled to claim its object to be a charitable purpose. Whereas an institution is not driven primarily by a desire motive to earn profit, but to do charity, so the advancement of the object of general public utility, it cannot but be regarded as an institution established for charitable purposes. So therefore, as I said, you have to look at the dominant object again. What is your dominant object? Is it charity or is it making profit? If your dominant object is charity, then you will not cease to be a charity in that sense merely because you have an incidental activity. That was the view which the Delhi High Court had. So far as 1020cc4 is concerned. Now, all these decisions have looked at an activity in the nature of trade, commerce, or business. Now, what about activity in relation to trade, commerce, or business? Can you say that merely because the charitable trust is rendering some activity to, say, a business, therefore it loses the exemption? Is that the, say, for instance, today, say a women's welfare organization maybe, say, running a canteen for a company or providing meals for a company. So would it mean that it loses the exemption because rendering a service to a business? And there we have the Andhra Pradesh High Court decision in Andhra Pradesh State Seed Certification Agency, which says this was a certification agency for seeds, and then a fee was charged for the certification, and the seed growers, so there they said, the Andhra Pradesh High Court said that the certification of seeds facilitates trade, commerce, or business by the client or the SSP who is the agent, and therefore the activities in relation to trade, commerce, or business, and you cannot ignore these words in relation to trade, commerce, or business. So it's therefore not a charitable purpose. And a similar view is taken by the Chandigarh Tribunal in Punjab State Seed Certification Authority. But there is a Delhi High Court decision in the case of GS1 India, where the Delhi High Court has looked at this aspect of what is the meaning of the term in relation to trade, commerce. The first part is, of course, talks about in the nature of trade, commerce, or business. I will not, for want of time, let me, the slide is with you, you can always read it. Here, they say that whether providing of services to persons engaged in trade, commerce or business, whether it's an activity in relation to trade, commerce or business, whether the legislative intent is to exclude any activity which has the aim and object of providing services to trade, commerce or business. The Delhi High Court said this is not free from doubt, but there is good reasons to hold that the prohibition is not reference to the activity of the beneficiaries, but activity of the assessee under the residuary clause. The intent is to exclude an assessee who carries on trade, commerce or business to feed charitable activities under the last limit, and then they said acquisition of income, etc. is no longer there. So what they're saying is, what you have to look at is your trade, commerce or business, and whether you are carrying on trade, commerce or business, whether this is incidental to that, or whether that entity is carrying on trade, commerce. Of course, one aspect is that if I myself am carrying on trade, commerce or business, then where is the question of, then I lose the exemption by application of 215, then where is the question? Now, point is, that trade, commerce or business may fall under the other clause, it may not fall under any other activity of general public utility. This may be, something which is partly incidental to that, and therefore, this may fall under that. So that's the only situation where this would apply. But otherwise, I think, but at least this Delhi High Court decision is something which has given a little bit of a relief to some SSCs. So therefore, now basically, therefore, if you look at 215, therefore, ultimately what the courts have taken the view is, what is your dominant purpose? Is your dominant purpose business or is your dominant purpose charity? If your dominant purpose is charity, you may charge something incidentally and you earn a surplus from that, that doesn't make it trade, commerce or business. Now it has to be really trade, commerce or business, and the trade, commerce or business is not in the general meaning of the term trade, commerce or business. One has to look at, is it actuated by profit motives? That's the way you have to look at it. I think that's the way one will look at section 250. Now let's quickly run through the other issues. The question here is, does education necessarily mean a recognized education institution at all? And we have the decision of the Supreme Court in the case of Lok Shiksha Trust, where the Supreme Court said that the word education connotes the process of training and development, knowledge, skill, mind, and character by normal schooling, and has not been used in the wide and extensive sense, according to which every acquisition of further knowledge constitutes education. This is the phrase which the department relies upon. So therefore they say that it means only students by normal schooling. So therefore only a class and bench type of thing, and only students. And then it's the sense in which word education has been used in 215 is a systematic instruction, schooling or training given to the young in preparation for the work of life. Then it also says, it also connotes the whole course of scholastic instruction which a person has received. So it's again not necessarily that scholastic instruction need not necessarily be only during the school days. Could it not be at a later point of time also? That's something which the courts have interpreted. And then the Supreme Court went on to say, although the term education as used in section 215 seems wider and more comprehensive than education through educational institutions, such as universities, whose income is given exemption under section 2082, provided it does not exceed for the purpose of profit. Yet, the question here before Supreme Court was, running of a newspaper, whether this can be education. It is educating public opinion, they said, and therefore they claimed exemption. So running of a newspaper. And they said that it seems that the educational effects of a newspaper publishing business are only indirect, problematic, and quite incidental. So that without imposing condition or qualification on the nature of information to be disseminated or material to be published, mere publication of news or views cannot be said to serve a purely or even a predominantly educational purpose in its ordinary and usual sense. So they said newspaper cannot be said to be education, and that was, so therefore it has to be read in that context. The observations of the Supreme Court need to be read, and that's how the courts have read it down at a later point of time. But unfortunately, the department still looks at the basic observation and does not look at the whole decision in its whole context. And we had the Gujarat State Cooperative Union decision in the light of the Gujarat High Court, where they said that by referring to instruction, schooling, or training given to young, it has only cited an instance as to what education is intended to be. We are certain that these observations were not intended to keep out of the meaning of the word education persons other than young. The expression schooling also means that schools instructs or educates, Oxford Dictionary. Supreme Court has observed that the word education also connotes the whole course of scholastic instruction with the person. This indicates that observations of the Supreme Court were not intended to give a narrow or pedantic sense to the word education. By giving, and then they said further, by giving further illustration of a traveller gaining knowledge, victims of swindlers and thieves becoming wiser, visitors to nightclubs adding to their knowledge the hidden mysteries of life. So Supreme Court said that also could be said to be education. No, that's not education the way it's going to be. So the Supreme Court has indicated that education is not used in a loose sense, so as to include acquisition of even such knowledge. Observation of Supreme Court only indicate a proper confinement of the word education in the context of 215. It is not proper to construe these observations in a manner in which they construed by tribunal when it infers that the word education is limited to schools, colleges and similar institutions and does not extend to any other media for such acquisition of knowledge. The observation of Supreme Court do not confine the word education only to scholastic instruction, but other forms of education also are included in the word education. And so, as noticed above, schooling also means instructive educating. It therefore means, cannot be said that the word education has been given an unduly restricted meaning by Supreme Court. Though in the context of 1022, the concept of education did not be given wide extended meaning, it surely would encompass systematic dissemination of knowledge and training in specialized subjects. Whether an education institution is existing solely for education can be decided with reference to activities actually carried on by it. Advancement of knowledge brings with it a suitable method of its dissemination. And though primary method of sitting in a classroom may remain ideal for most of the initial education, it may become necessary to have a different outlook for further education. It's not necessary to tailor the concept of education to a particular formula. Its progress lies in acceptance of new ideas and development of appropriate means to reach them to the recipient. Like for instance, today, sitting in a classroom was maybe fine at one point of time. Today, for instance, you could have a video classroom, a virtual classroom. So does that mean that that is not education? I think that's what the school said. There are new ideas which come up, as the Gujarat High Court said. New ideas come up, and therefore, though that might have the traditional way, it's not necessarily so. We have also the Gujarat High Court decision in case of Saurashtra Education Foundation, which is cited by the department very often for saying that no, you are not educated. Now, what you have to remember here is, in Saurashtra Education Foundation, the question was in context of exemption under section 1022. 1022, which is now equivalent to 1023C6. So, there the question there was, because it is not affiliated to a university, does it cease to be an educational institution? And there the Gujarat High Court said that yes, for the purpose of 1022, yes, you have to have a restricted meaning of the term for educational institution. The education has to have a restricted term, it has to be affiliated to university, etc. But so far as the 11.1a is concerned, so far as section 215 for the purpose of 11.1a is concerned, there you have to give a broader meaning. They are saying that in section 11.1a, read by 215, it is the activities which are in focus. Whereas in 1022, both institution and activities is in focus. And education institution under 1022 is therefore more than carrying on charitable activity in the field of education as contemplated by section 215. In fact, earlier they said that an institution may carry on education activities that are being carried on the SSC without imparting formal education and without being affiliated to or accountable to any authority. Such a trust can certainly be considered as qualified for exemption under 11.1a, read by section 215. So therefore, this really helps you in a case where they say that this is not education. They say that merely because you are not having the affiliated to university or other. We have the Bombay Tribunal decision in the case of Indian Institute of Bankers, again, where they said that no formal school or college is there in the way we understand fixed hours of study, lunch recess, principal, staff, playground, rules for discipline and life. But that does not mean that the activities pursued are not educational activities. There is no requirement in 1022 that it should run a school or college in the formal sense in order to qualify for. And then they will distinguish Lok Shiksha and Trust that what was the issue before the Supreme Court. And they said that even in that decision, there was nothing to suggest that the court meant to convey that educational activities could be pursued only in a formal atmosphere such as a school or college. We have the Bombay High Court decision in the case of National Safety Council, where objects of education in public in regard to safety, protection and health among industrial workers to organize and conduct programs, lectures, conferences and other activities for promoting free discussion on all matters and questions related to safety measures, procedure and research. To conduct that repayment of the loan will be regarded as an application of income for charitable purposes. And based on that logic, the various courts have taken the view, including the Bombay High Court in the case of the Institute of Banking Personnel Selection. All these have taken the view that really what you are doing is you are spending that surplus either out of borrowing or out of past surplus. So therefore, when you spend in the subsequent year, so you have a deficit in this year because you utilize your other funds for that. And what you are doing then is in the subsequent year you are recouping that. So therefore, in the out of subsequent year's income, and therefore it's a necessary deduction in the other year's next year's income. And therefore, the question therefore people very often ask that what if I not filed my return of income in time? Does it lapse? Now section 80 applies only to a situation where you're claiming under section 72 or section 74, so that it's only in those situations that it applies. It does not apply to this situation of a charitable trust. So therefore, it would necessarily have to be allowed to you as a deduction from the income, as an application of income in the subsequent year. Then application under section 11.2. The question is very often people ask, should I file one form number 10 or should I file for each year file form number 10? Should I file, because the form number 10, if you say, it says the I'm accumulating the surplus of assessment year so and so many subsequent years. So people automatically feel that, okay, for 5 years I will accumulate. Now what happens there is, the question is that valid, or do you have to file separate form for each year? Well, you can do it both ways, frankly speaking. There is a Bombay tribunal decision which says that the application has to be made each year, and they say that general application for over a period of time is not possible. There is also another Bombay tribunal which says notice for application is possible not only for current but also for subsequent assessment year going by the form. So therefore, it seems to be a controversial area. But frankly speaking, I think the problem really is this. Let's look at it in year 1. You file an accumulation saying that for year 1 and 4 subsequent assessment years, I will spend it in the next 4 years. So I'm accumulating it for that. Now what happens is, in year 6, the entire accumulation from year 1 to 5 becomes taxable. So therefore, what happens is, accumulation of year 5 becomes taxable in year 6. So that's where the problem really arises. And therefore, whereas if you file for year 1 separately, that becomes taxable in year 6. Year 2 separately becomes taxable in year 7. So, that's the way. Actually, and it's not year 6 actually. See, what happens is, when in year 1, if your income arises